New guidance just got released that could affect your retirement plan. Now, this is guidance on Section 603 of Secure Act 2.0. You might be wondering, what is Section 603? It's a provision from Secure Act 2.0 that says that if you're a high income earner, somebody that's earning $145,000 or more, and you're 50 or older, then your catch-up contribution, which is $7,500 for 2023, would have to go to the Roth side of that retirement plan. Now, this provision or this guidance could affect your retirement plan, even if you're not a high income earner and even if you're not 50 or older. So first, this guidance says that you don't have to implement all of this for the next 2 years. So you have 2 years to comply. That's first. Second is, how does it affect everybody? Well, it's saying that if you have a plan that is required to have a Roth side for a high income earner, then you have to offer it to everybody in the plan. You can't just say this is only for those that are 50 or older. So if that is the case and you're under the age of 50 and there wasn't previously a Roth side to your retirement plan, there likely will be moving forward. And we're likely to see the Roth side to retirement plans as more or less a staple. And it's probably how you feel already, but not every single plan out there has a Roth side to that retirement plan. But in the future, it looks like that's the way it's going to go. Now, as far as implementing this for over the next 2 years, if you are a high income earner and you are 50 or older for that catch-up contribution, and you make that contribution on a pre-tax basis, it's okay. It's not going to result in additional taxes or penalties or collapse the plan or have any sorts of negative effects on the plan. You have 2 years to comply. So if you strategically wanted to still put it into the pre-tax side, it's likely that you still can, as long as your employer isn't ahead of the game and trying to implement this stuff a little bit sooner. So that's first. The next thing I want to talk about are 3 additional points that the IRS points out in this guidance that I find kind of interesting and will also affect other plans out there. So the first one is it's defining which plans are, or sort of, which plans are affected by this provision. And it's saying that this would not apply in the case of an eligible participant who does not have wages as defined in Section 3121A. And they're basically saying that for this guidance, that if an eligible participant did not have any wages for purposes of FICA for the preceding calendar year, FICA is Social Security and Medicare taxes, for the preceding calendar year, because the individual was a partner or self-employed. So if you're a self-employed individual, like a solo 401k, you don't have to comply with this provision. This is only for employees who are basically subject to FICA. So if you're self-employed, even though you're paying Social Security and Medicare taxes, it is self-employment taxes, not FICA taxes. So that is point number 1. Number 2 is the contributions to the Roth side will go into the Roth side if you're a high income earner and you're 50 or older, regardless of your election. So even if you go out there and try to elect pre-tax contributions, your employer can simply switch it to comply with this provision so the plan doesn't collapse or you don't have any additional taxes or penalties as a result. The third point has to deal with multiple jobs, and this was also an interesting one, but it makes sense when you sit there and think about it for a minute. Now, this is saying that if an eligible participant has multiple jobs, then it is basically on a per job basis. So their example is if an eligible participant's wages for the calendar year were $100,000 from one participating employer and $125,000 from another participating employer, then the participant's catch-up contributions under the plan for the next year would not be subject to Section 414V7A, which is basically what this is talking about. Even if the participant's aggregate wages for the participating employer for the prior calendar year exceeded $145,000 as adjusted. So if you add them all up and you're over $145,000, it doesn't matter. It's on a per employer basis. Now, I would assume that they did this because there's no way for the employer to know how much you're earning outside of that one job. And if they did, then you'd have to give all that information over to them. So I'm sure they thought, you know what, make it on a per employer basis, not in aggregate, because there's no way to fix this. And if the employee needs to fix it, they're going to have to go back to their employer to fix the plan. And that's probably a huge headache. So the guidance that they released was you don't have to do it. It's on a per employer basis. So that is the update to Secure Act 2.0, Section 603. And I covered this in a previous video. If you want to know more about Secure Act 2.0, or if you have questions on it, let me know in the comments down below. And if you've enjoyed this video, be sure to subscribe, and we'll see you on the next one.